In today's lecture, we would like to discuss prevention of corruption. So, first of all, we'll take a brief idea about prevention of corruption. So, Prevention of Corruption Act 1988 came into force on 9 September 1988. It was aimed at making anti corruption laws more effective by widening their coverage and by strengthening the provisions to make the overall statute more effective. And now we'll discuss salient features of Prevention of Corruption Act 1988. So it incorporates the Prevention of Corruption Act 1947, the Criminal Amendment Act 1952, and Section 161 to 165A of Indian Penal Code with certain original provisions. It is enlarged the scope of the definition, such as public duty and also public servant. It is shifted to the very burden of proof from the prosecution as mentioned in criminal procedure code to the accused who is charged with the offense. The provisions of this act clearly state that the investigation is to be made by an officer not below the rank of deputy superintendent of police. So the act covers corruption act or corrupt acts as bribe, then misappropriation, then obtaining any pecuniary advantages, possessing of assets disproportionate to income and the like. So, the very Prevention of Corruption Act of 1988 was amended in 2008. So, in the very 2018 amendment attempted to bring the corruption Prevention of Corruption Act of 1988 in line with the United Nations Convention Against Corruption in 2005, which was ratified by India in 2011. So the added amendments inserted into the Act the very definition of undue advantage. So the Amendment Act has defined undue advantage to mean any gratification other than legal remuneration that a public servant is permitted to receive. And the second inserted under the amendment is liability of persons offering bribe to public servants. So, persons who are liable for offering a bribe to public servant as Previously, the Prevention of Corruption Act of 1988 did not contain a separate provision for a person who gives or promises to give an undue advantage. However, the Amendment Act of 2018 makes giving an undue advantage by a person to a public servant a specific punishable offense, and the third enforcement under the Amendment Act of 2018 is offering a bribe to commercial organizations. So it now provides that if a commercial organization commits any of the offenses listed in the Prevention of Corruption Amendment Act of 2018 with the intention to obtain or retain business or obtain or retain an advantage in the conduct of its business, then such commercial organization shall be punishable. And the fourth enforcement under the new amendment of 2018 is prior sanction for investigation and prosecution. So, regarding prior sanction for investigation and prosecution, the Prevention of Corruption Amendment Act of 2018 required prior sanction of the appropriate government for prosecution of serving public officials. Also, the Amendment Act extends this protection of requirement of prior approval to investigation prior to prosecution. And the fifth enforcement under the new Amendment Act is regarding attachment of property. The Amendment Act has also provided for application of the Prevention of Money Laundering Act 2002 and Criminal Law Amendment Ordinance of 1944 for attachment and administration of property procured by means of an offense under the Prevention of Corruption Amendment Act of 2018. So the next or the last one that is inserted under the 2018 Amendment Act is enhancement of punishment. So, regarding that, now punishment has been increased from a minimum imprisonment term of 6 months to 3 years, and from a maximum 5 years to 7 years. And now we'll discuss those landmark judgments. So, in regard to that, we would like to discuss the first important landmark judgment, that is Subramaniam Swamy versus Manmohan Singh in 2012. The Supreme Court addressed the issue of delay in granting sanction to prosecute a public servant. Subramaniam Swamy had sought permission to prosecute the then telecom minister A. Raja in the 2G spectrum case. The Supreme Court held that undue delay in granting such sanction could lead to frustration of the intent of the Prevention of Corruption Act. This judgment emphasized the need for timely decisions to prosecute corrupt officials, highlighting that a delay could impede the fight against corruption. And now we'll go to another important judgment, that is Narayan Nambiar versus State of Kerala, and the very year was 1963, where Supreme Court, as it was the foundational case for the Prevention of Corruption Act, the Supreme Court interpreted the term public servant broadly, ensuring that a wide range of officials come under the Act's purview. The judgment underscored the importance of maintaining the integrity of public officials and laid down principles for interpreting the very scope of the Act. And now we discuss another important landmark judgment is P.B. Narasimha Rao versus State in 1988. The Supreme Court raised the question about the former Prime Minister P.B. Narasimha Rao was accused of corruption in the infamous JMM bribery case. The Supreme Court held that members of Parliament were public servants under the Prevention of Corruption Act, this broadening the application of the Act to include elected representatives. This judgment was crucial in ensuring that legislators are also held accountable under anti-corruption laws. And now we'll discuss another important judgment, that is L. Narayan Swamy versus State of Karnataka, decided by the Supreme Court in 2016. So, in this case, Supreme Court ruled that a public servant can be prosecuted under the Prevention of Corruption Act even after their retirement for acts committed while in service. This judgment reinforced the principle that retirement does not absolve public officials from being held accountable for corrupt practices during their tenure. And now we'll discuss another important judgment, that is Central Bureau of Investigation versus B.L. Burma in 1997. Supreme Court clarified the admissibility of evidence collected during investigation under the Prevention of Corruption Act. It was held that even if the evidence collection involved procedural lapses, it could still be admissible if it served the broader objective of combating corruption. This ruling helped streamline the process of prosecuting corrupted officials and corruption cases. And now we'll discuss another important judgment, Beneath Narayan versus Union of India in 1996. The decision was tendered by the Supreme Court. Here, although not exclusively about the Prevention of Corruption Act, this landmark judgment had significant implications for anti-corruption efforts in India. The Supreme Court laid down guidelines for ensuring the independence and effectiveness of the Central Bureau of Investigation or CBI, which is upon the investigating agency in corruption cases. The judgment emphasized the need for a fair and transparent investigation process, free from political interference. And now we discuss another important landmark judgment is BK Taneja versus State of Maharashtra, and it was decided in 2018 by the Supreme Court. In this particular case, Supreme Court reiterated the importance of adhering to the procedural safeguards provided in the Prevention of Corruption Act. The court squashed the proceedings against the accused due to the failure of the prosecution to obtain proper sanction before initiating the case. This judgment highlighted the necessity of following due process in corruption investigations. And now we'll discuss another most important leading case, that is State of Maharashtra versus Venkatrao Shirki in 2011. The Supreme Court held that mere possession of assets disproportionate to known sources of income does not constitute an offense under the Prevention of Corruption Act unless it is proved that the assets were acquired through corrupt means. This judgment clarified the burden of proof required in cases of disproportionate assets. And now we'll discuss the very conclusion that we have made regarding this particular chapter and topic that we are dealing, and that is Prevention of Corruption Act. So before making such discussion regarding the very conclusion, now we want to discuss the very summary that we have made regarding the implementation of this act. So, in that connection, we would like to discuss one incident of 2019. So, in 2019, a reference was made by a division bench of the Supreme Court to a larger bench. Upon observing that insistence of direct proof or primary evidence for proving the demand may not be in consonance with the view taken by many judgments, there were instances wherein, despite the absence of primary evidence of the complainant, the Supreme Court had sustained the conviction of the accused by relying on other evidence. So the five-judge bench of the Supreme Court had reserved the judgment on 23 November 2019. In an important ruling, the Supreme Court held that direct evidence of the demand or acceptance of bribe is not necessary to convict a public servant under the Act, and that such fact can be proved through circumstantial evidence. So also, Supreme Court expressed that, referring the earlier verdicts of the Supreme Court, the bench said corruption among public servants has become a gigantic problem, and no facet of public activity has been left unaffected by it. So, as to the very conclusion of this landmark judgments, as we found the very assessment made regarding these important judgments relating to the Act Prevention of Corruption Act 1988 and amended in 2018. These landmark judgments have played a pivotal role in shaping the legal landscape of anti corruption measures in India. They underscore the judiciary's commitment to ensuring accountability and transparency among public officials, while also emphasizing the importance of procedural rigor and fairness in prosecuting corruption cases. The evolving jurisprudence continues to strengthen the fight against corruption, reinforcing the rule of law and public trust in the judicial system. So, in this lecture, we have completed regarding the very provisions of Prevention of Corruption Act 1988 and as amended in 2018, which are the new features, those which are inserted under the amendment of 2018, like the definition of undue advantage, liability of persons offering bribe to public servants, and also offering a bribe to commercial organizations, and the requirement of prior sanctions for investigation and prosecution. Then another instrument is the attachment of property of such public officials who found to be convicted of corruption or corrupt practices. So also, the very Amendment Act 2018 also enhanced the very punishment for those who are convicted under the provisions of the Act. So also, we have discussed the very important landmark judgments on corruption cases and the judgments delivered by the Supreme Court, and we made an estimation and analysis on those judgments, and also the very conclusion that we made. It is also out of those Supreme Court landmark judgments. So we have completed prevention of corruption.